Okay, I'm in the BARBRI Conviser mini review. Part D, cross-examination within the testimonial evidence section of the evidence review. Cross-examination of adverse witnesses is a matter of right in every trial of a disputed issue of fact, but the scope of cross-examination is frequently a matter of judicial discretion. Restrictions on scope. Cross-examination is generally limited to Romanet 1, the scope of direct examination, including all reasonable inferences that may be drawn from it, and Romanet 2, testing the credibility of the witness. 3, collateral matters. The cross-examiner is generally bound by the answers of the witness to questions concerning collateral matters. Thus, the response may not be refuted by extrinsic evidence. However, certain recognized matters of impeachment, such as bias, interest, or a conviction, may be developed by extrinsic evidence because they are sufficiently important. The trial court has considerable discretion in this area. Credibility, impeachment, subsection E of the testimonial evidence section. Impeachment means the casting of an adverse reflection on the veracity of the witness. 1, accrediting or bolstering. Generally, a party may not bolster or accredit the testimony of his witness, example, by introducing a prior consistent statement until the witness has been impeached. However, in certain cases, a party may prove the witness made a timely complaint or a prior statement of identification. The prior identification may also serve as substantive evidence that the identification was correct. Any party may impeach. Under the federal rules, a witness may be impeached by any party, including the party calling him. Exam tip: when a question involves a party impeaching his own witness, be sure to avoid the following wrong answer choices reflecting the traditional rule which prohibits impeaching your own witness unless the witness is an adverse party or identified with an adverse party, is hostile and affirmatively uncooperative, is one whom the party is required by law to call, or gives surprise testimony that is affirmatively harmful to the party calling him. So those are all the wrong answer choices from the traditional rule. So I don't even know why I read them. Impeachment methods: cross-examination and extrinsic evidence. A witness may be impeached either by cross-examination, by eliciting facts from the witness that discredit his own testimony, or by extrinsic evidence, by calling other witnesses or introducing documents that prove the impeaching facts. Certain grounds for impeachment require that a foundation be laid during cross-examination before extrinsic evidence can be introduced. Other grounds allow impeachment to be accomplished only by cross-examination and not by extrinsic evidence. Note, the term cross-examination is used for convenience because it is usually an adverse witness who is impeached. But remember that party may impeach his own witness, which would be on direct or redirect examination. The traditional impeachment devices follow. Prior inconsistent statements. A, just read the rest of these. Foundation. Well, under A, there's a foundation for extrinsic evidence and evidentiary effect of prior inconsistent statements. B, bias or interest. C, conviction of crime. Within that is the type of crime involving, say, for instance, dishonesty or false statement. Felony not involving dishonesty or false statement. And there's a lot of other numbers beyond the type of crime. There's remote, juvenile, and constitutionally defective convictions are not a visible effect of a pardon. No foundation required for extrinsic evidence. Then there's specific evidence of misconduct, bad acts, extrinsic evidence not permitted. E, F, and G. So E, finishing up this section of, again, impeachment methods. E is opinion or reputation evidence of untruthfulness, and F, sensory deficiencies, and G, contradictory facts. There is a lovely table on page 26, which takes every impeachment method and gives you the means of proof and the foundation. So I actually might start here before I read it more substantively. Prior inconsistent statements means of proof is cross-examination and extrinsic evidence, if not a collateral matter. The foundation is that the witness must be given opportunity to explain or deny the inconsistent statement, exceptions for hearsay declarants and party opponents. Bias or interest means of proof given in cross-examination or extrinsic evidence. The foundation is that the witness must be asked on cross-examination about facts showing bias or interest before extrinsic evidence is allowed. If these facts are admitted on cross-examination, admissibility of extrinsic evidence is within court's discretion. Conviction of crime must be a felony or crime involving dishonesty. The means of proof is cross-examination or records of judgment. No foundations required. Specific instances of misconduct, bad acts, cross-examination is the only means of proof, and no foundation is applicable. And opinion or truth, reputation for truthfulness, means of proof is calling other witnesses. The foundation, none is required. Sensory deficiencies, cross-examination and extrinsic evidence, no foundation is required. And contradictory facts, means of proof is by both cross-examination and extrinsic evidence, if not a collateral matter, and no foundation is required. So let's go into each one and define these impeachment methods. Cross-examination and extrinsic evidence. Okay, I already read that. Prior inconsistent statements. A party may show by cross-examination or extrinsic evidence that the witness has, on another occasion, made statements inconsistent with his present testimony. To prove the statement by extrinsic evidence, a proper foundation must be laid, and the statement must be relevant to some issue in the case. Foundation for extrinsic evidence. Extrinsic evidence may be introduced to prove a prior inconsistent statement only if, Romanet 1, the witness is at some point given an opportunity to explain or deny the statement, and Romanet 2, the adverse party is at some point given an opportunity to examine the witness about the statement. Exceptions, Romanet 1, the foundation requirement does not apply if the prior inconsistent statement is an opposing party statement. Romanet 2, an inconsistent statement by a hearsay declarant may also be used to impeach despite the lack of foundation. And Romanet 3, under the federal rules, foundation requirements may be dispensed with where justice requires. For example, the witness is unavailable when an inconsistent statement is discovered. I'm using a highlighter because I hid my note cards, but I want to highlight this because all those Romanets are elements, and I have to memorize all of them. So it's not just good enough to underline something. I'm going to return to this. Let's hope and talk about that. Exam tip. Remember the MBE follows the federal rule. Okay, good to know. Under the rules, the opportunity to explain or deny need not come before introduction of a prior inconsistent statement. Need not come before introduction of a prior inconsistent statement. So, bias or there's one more section in the prior inconsistent statement. It is usually prior inconsistent statements are hearsay, admissible only for impeachment purposes. If, however, the statement was made under oath at a prior proceeding, it is admissible non-hearsay and may be admitted as substantive evidence of the fact stated. This is non-hearsay. Right. So bias or interest. Non-hearsay if it's been said under oath. So important. Bias or interest is another impeachment method. Evidence that a witness is biased or has an interest in the outcome of the suit tends to show the witness has a motive to lie. The foundation for extrinsic evidence. Most courts require that before a witness can be impeached by extrinsic evidence of bias or interest, he must first be asked about the facts that show bias or interest on cross-examination. Watch for facts indicating that the foundation requirement for extrinsic evidence of bias or interest has been fulfilled. Evidence that is required inadmissible is otherwise evidence that is otherwise inadmissible. Arrest, liability insurance may be introduced if relevant for these impeachment purposes, provided the proper foundation is laid. So we're not allowed to, because of policy reasons, policy exceptions, we can't bring in evidence of like liability insurance to try to show negligence or anything of that nature, but we can introduce it if like the person is working for the insurance company that is supporting the party that would have to, I guess, file an insurance claim or be the beneficiary of one. So stuff like that involving the insurance company that is indicative of a bias or interest is admissible. Watch for facts indicating, okay, I think I just read that. And conviction of a crime, a witness may be impeached by proof of a conviction. Arrest or indictment is not sufficient for certain crimes. A pending review of appeal does not affect the use of a conviction for impeachment. Proof. So this is proof of a conviction, which is an arrest or indictment, is not sufficient. So what is proof then? If we know what it's not, what is it? Anyway, type of crime. Any crime involving dishonesty or false statement. A witness may be impeached by any crime, felony, or misdemeanor requiring an act of dishonesty or false statement. The court has no discretion to bar impeachment by these crimes. Exam tip. Although many crimes are arguably dishonest in nature, courts interpret this category narrowly to include only crimes in the nature of falsity, perjury, false statement, criminal fraud, embezzlement. False pretense. Simple theft, for example, generally is not considered a crime of dishonesty or false statement. I didn't know false statement was a crime. Wait, false statement is a crime. Here it says example, perjury, false statement. So why is that generally not considered a crime of dishonesty or false statement? Got it. All right. Felony not involving dishonesty or false statement. A witness may also be impeached by a felony that does not involve dishonesty or false statement, but the court has the discretion to exclude it if the witness being impeached is a criminal defendant and the prosecution has not shown that the conviction's probative value outweighs the prejudicial effect, which favors exclusion. Or in the case of other witnesses, the court determines that the conviction's probative value is substantially outweighed by its prejudicial effect. The standard 403 balancing test favors admission. Remote, juvenile, and constitutionally defective conditions not admissible. Generally, if more than 10 years have elapsed since the date of conviction or the date of release from confinement, whichever is later, the conviction is inadmissible. However, the court has discretion to admit remote convictions in extraordinary circumstances. Juvenile convictions are similarly inadmissible. A conviction obtained in violation of the defendant's constitutional rights is invalid for all purposes, including impeachment. Effective pardon. And the case on the point here, I think, is like Davis versus Alaska. Anyhow, effective pardon. A conviction may not be used to impeach a witness if the witness has been pardoned and the pardon is based on innocence or the person pardoned has not been convicted of a subsequent felony. No foundation required for extrinsic evidence. A prior conviction may be shown by either direct or cross-examination of the witness or by introducing a record of the judgment. No foundation is necessary. Note that if A party introduces the evidence of a prior conviction herself, example, to take out the sting of being impeached. On cross-examination, she cannot later claim on appeal that the conviction was erroneously admitted. Specific instances of misconduct, bad acts. Under the federal rules, subject to discretionary control of the trial judge, a witness may be interrogated upon cross-examination with respect to an act of misconduct only if the act is probative of truthfulness. For example, it is an act of deceit or lying. However, the cross-examiner must inquire in good faith. So a witness may be interrogated upon cross-examination with respect to an act of misconduct only if the act is probative of truthfulness or inquire in good. However, the cross-examiner must inquire in good faith. They must have some reason to believe that what they're asking about could actually be valid. You can't just say, did you this, did you that? It's not 50 questions. Extrinsic evidence not permitted. Extrinsic evidence of bad acts to prove misconduct is not permitted. A specific act of misconduct offered to attack the witness's character for truthfulness can be elicited only on cross-examination of the witness. The cross-examiner may not be elicited only on cross-examination of the witness. The cross-examiner may not reference any consequences the witness may have suffered as a result of his bad act. So you cannot bring these in, except on cross-examination exam tip. Keep in mind that asking about specific instances of misconduct does not include inquiring about arrests. An arrest itself is not a bad act. Thus, it is permissible to ask a witness whether he embezzled money from his employer. It is not permissible to ask him whether he was arrested for embezzlement. Opinion or reputation evidence of truthfulness. A witness may be impeached by showing that he has a poor reputation for truthfulness. This may include evidence of reputation in business circles as well as in the community in which the witness resides. Under the federal rules, an impeaching witness may also state his own opinion as to the character of a witness for truthfulness. Sensory deficiencies. A witness may be impeached by showing, either on cross-examination or by extrinsic evidence, that his faculties of perception and recollection are so impaired as to make it doubtful that he could have perceived those facts. A witness may also be impeached by showing that he had no knowledge of the facts to which he testified. Contradictory facts. Extrinsic evidence of facts that contradict a witness's testimony may sometimes be admitted to suggest that a witness's mistake or lie on one point indicates erroneous or false testimony as to the whole. Extrinsic evidence of contradictory facts to impeach is false testimony as to the whole. Extrinsic evidence, I think I reread that. Contradictory facts. Extrinsic evidence of facts that contradicts a witness's testimony may sometimes be admitted to suggest that a witness's mistake or lie on one point indicates erroneous or false testimony as to the whole. Extrinsic evidence of contradictory facts to impeach is permitted where 1. The witness's testimony on a particular fact is a material issue in the case. The testimony on a particular fact is significant on the issue of the credibility. Or 3. The witness volunteers testimony about a subject as to which the opposing party would otherwise be precluded from offering evidence. However, as discussed in 4 below, extrinsic evidence is not permitted to prove contradictory facts that are collateral. Impeachment on collateral matter. Where a witness makes a statement not directly relevant to the issue in the case, the rule against impeachment on a collateral matter applies to bar his opponent from proving the statement untrue either by extrinsic evidence or by a prior inconsistent statement. So in this application, I think collateral means like not central, not essential, of little consequence, side issue. I always think of it as something different. Impeachment of hearsay declarant. Under the federal rules, the credibility of someone who does not testify but whose out-of-court statement is introduced at trial may be attacked. If attacked, may be supported by evidence that would be admissible if the declarant had testified as a witness. The declarant need not be given an opportunity to explain or deny an prior inconsistent statement. In addition, the party against whom the out-of-court statement was offered may call the declarant as a witness and cross-examine him about the statement. Should have been done in the first place. Rehabilitation. A witness who has been impeached may be rehabilitated by the following method. Explanation on redirect, good reputation for truthfulness, prior consistent statement. So those are the only three, actually. The witness on redirect may explain or clarify facts brought out on cross-examination. Good reputation for truthfulness. When a witness's character for truth and veracity has been attacked, other witnesses may be called to testify to the good reputation for truthfulness of the impeached witness or to give their opinions as to the truthfulness of the impeached witness. Prior consistent statement. There are two situations in which the party may rehabilitate the witness by showing a prior consistent statement. First, if the testimony of the witness has been attacked by an expressed or implied charge that the witness is lying or exaggerating because of some motive, a previous consistent statement made by the witness before the onset of the alleged motive is admissible to rebut this evidence. Second, if the witness's testimony is impeached on some different ground other than the general attack on the witness's character for truthfulness, such as an inconsistency or a sensory deficiency, counsel may introduce a prior consistent statement made by the witness if, under the circumstances, it has special tendency to rehabilitate the witness's credibility. A prior consistent statement that is admissible to rehabilitate the witness's credibility also is admissible as substantive evidence of the truth of its contents. So subpart F within testimonial evidence is objections, exceptions, and offers of proof. Then we come to testimonial privileges in the next section. So before getting to hearsay, so I'm just going to finish to the point of privileges in this section ahead of it. Objections, exceptions, and offers of proof. Objections at trial should be made after the question but before the answer if the question calls for inadmissible matter. Otherwise, a motion to strike must be made as soon as the answer emerges as inadmissible. At a deposition, objections to the form of the question or to a testimonial privilege should be made when the question is asked or it may be waived. Objections based on the substance of a question or answer may be postponed until the deposition is offered in evidence. Exam tip: failure to object is deemed a waiver of any ground for objection. Thus, if no objection is made, otherwise inadmissible evidence will be admitted. Specificity of objections. General objections. A sustained general objection, one that does not state the grounds of the objection, will be upheld on appeal if there was any ground for the objection. An overruled general objection will be upheld on appeal unless the evidence was not admissible under any circumstances for any purpose. Specific objections. A sustained specific objection which states the reason for the objection will be upheld on appeal only if the ground stated was correct or if the evidence excluded was not competent and could not be made so. Opening the door. One who opens evidence on a particular subject thereby asserts its relevance and cannot complain if his adversary thereafter offers evidence on the same subject. How to make it into this section. Rule of completeness, writings and recorded statements. I get it, because it often comes up. Well, that's a reason to object. Is character evidence, but if the door's been opened and they don't actually close it all the time. So rule of completeness. Writings and recorded statements where part or all of a writing or recorded statement is introduced into evidence, the adverse party may require the proponent of the evidence to introduce any other part or any related writing or recorded statement that ought in fairness to be considered. So that's the rule of completeness. Ought in fairness to be considered. Adverse party may require the proponent of the evidence to introduce any other part or any related writing or recorded statement that ought in fairness to be considered. Motion to strike unresponsive answers. Examining counsel may move to strike an unresponsive answer, but opposing counsel may not. Exceptions. But you can object to it, can you not? Objection, unresponsive. Who moves to strike? Can the judge? This itself is unresponsive to what I need to know. Exceptions. It is not necessary for a party to accept from a trial ruling in order to preserve the issue for appeal in most states. So it is not necessary for a party to accept from a trial ruling in order to preserve the issue for appeal in most states. And that's called exceptions. I have no idea what that's supposed to mean. Except, EXCEPT, exceptions. Offers of proof. An offer of proof may be made disclosing the nature, purpose, and admissibility of rejected evidence to persuade the trial court to hear the evidence and to preserve the evidence for review on appeal. It may be made by witness testimony, a lawyer's narration, or tangible evidence marked and offered. I don't know what to make of these two things. These exceptions and offers of proof. I'm going to read this one more time, but it's in the section called Objections, Exceptions, and Offers of Proof. Exceptions. It is not necessary for a party to accept from a trial ruling in order to preserve the issue for appeal in most states. Offers of proof. An offer of proof may be made disclosing the nature, purpose, and admissibility of rejected evidence to persuade the trial court to hear the evidence and to preserve the evidence for review on appeal. May be made by witness testimony, a lawyer's narration, tangible evidence marked and offered. I think, okay, that makes sense now. So testimonial privileges is interesting. I'm sure there's going to be a table on this, so I'm just going to introduce the federal common law privileges of attorney-client privilege, spousal immunity, privilege for confidential marital communications, psychotherapist, social worker, client privilege, clergy penitent privilege, and governmental privileges. In diversity cases, the state law of privilege applies, so that's something that's often tested. General considerations are the persons who may assert the privilege, the confidentiality is a requirement, comment on privilege forbidden, waiver, eavesdroppers. So attorney-client privilege, they go into in detail on page 30. Obviously, there has to be an attorney-client relationship. Corporate clients means that the attorney isn't representing any employees. Confidential communication means that it has to be, like if it's in a corporate setting, communication through agents and no privilege where attorney acts for both parties. That kind of all sounds a lot like corporate problems. Client holds privilege. Privilege applies indefinitely, like even after the client dies. When the privilege does not apply, there is no privilege if the attorney's services were sought in aid in the planning or commission of something the client should have known was a crime or fraud regarding a communication relevant to an issue between parties claiming through the same deceased client. For communication, I think that's like trying to interpret a will. I witnessed that in NBE questions yesterday. For a third, for communication, this is when privilege, the ACP privilege lies for the communication relevant to the issue of breach of duty in a dispute between the attorney and the client, right? Of course, like if you're trying to get paid and they want to ask some details, you can take the stand. Where the client has put the legal services at issue in the case, for instance, saying that you're inept as a lawyer. Attorney work product, limitations on the waiver of attorney-client privilege and work product rule. There's a lot bolded here, so I'm going to just read this, but I do plan on skimming because I know there's going to be a table of summary. A voluntary disclosure of privileged material operates as a waiver of the attorney-client privilege or work product protection only with respect to the disclosed material. Undisclosed privileged material is subject to the waiver only if the waiver is intentional. The disclosed and undisclosed material concern the same subject matter, and the material should be considered together to avoid unfairness. There is no waiver if the disclosure was inadvertent and the holder took reasonable steps to prevent disclosure to rectify the error. Look for patterns on the exam where a party discloses documents during discovery that would ordinarily be privileged under the attorney-client privilege or work product rule if the disclosure is the result of an innocent mistake, and then there's no waiver. However, if the documents are voluntarily disclosed, then the waiver is effective with respect to those documents only unless the disclosing party intentionally waived protection of other privileged material that concerns the same subject matter and of which disclosure is necessary to prevent unfairness to the opposing party. So I'm skipping over physician-patient privilege. But when it doesn't apply is when the patient puts his physical condition at issue, physician's assistant is sought to aid wrongdoing, like a crime or a tort. The communication is relevant to an issue of breach of duty and a dispute between the physician and patient. This is very similar to the ACP privilege, and the patient agreed by contract, insurance policy to waive the privilege, or it is a federal case applying the federal law of privilege. Criminal proceedings. I'm getting nothing from that. Remember that when a psychiatrist is a doctor involved, the applicable privilege is the psychotherapist client privilege below, which is more widely accepted in all proceedings than is the physician-patient privilege. Psychotherapist, social worker client privilege is related to marriage, spousal immunity. Who holds the privilege? Privilege for confidential marital communications. When neither marital privilege applies. You've got a table here. Privileges related to marriage. So the spousal immunity, one spouse cannot be compelled to testify against the other spouse in any criminal proceeding. Only the witness spouse may invoke spousal immunity. The party spouse cannot prevent the witness spouse from testifying, and the privilege may be claimed only during marriage but covers information learned before and during the marriage. Confidential marital communications made in reliance upon the intimacy of the marital relationship are privileged. The privilege applies in both civil and criminal proceedings. Both spouses have the privilege not to disclose and to prevent the other from disclosing a confidential marital communication. I had no idea that was true. The privilege survives the marriage but covers only statements made during the marriage. Then there's privilege against self-incrimination. Clergy or accountant privilege, professional journalist privilege, and governmental privileges. So actually, some of these are interesting because I never really heard of them before. The privilege against self-incrimination under the Fifth Amendment of the Constitution, a witness cannot be compelled to testify against himself. Any witness compelled to appear in a criminal or civil or criminal proceeding may refuse to give an answer that ties the witness to the commission of the crime. Clergy and accountant, kind of rare. Professional journalist privilege. There is no constitutional right for a professional journalist to protect his source of information. So any privilege in this area is limited to individual state statutes on the subject. Okay. Weird. I'm going to revisit that in constitutional law because and governmental privileges. Official information not otherwise open to the public, or the identity of an informer may be protected by a privilege for the government. No privilege exists if the identity of the informer is voluntarily disclosed by the holder of the privilege. Exclusion and sequestration of witnesses. Upon a party's request, the trial judge must order witnesses excluded from the courtroom. But it has to be on the party's request. It can't just be sua sponte, I guess. The judge may also do this on, it can be sua sponte. The judge, however, may not exclude a party or a designated officer or employee of a party, a person whose presence is essential to the presentation of a party's claim or defense, or 3, a person statutorily authorized to be present. Witnesses called or examined by the court. A court may examine a party's witness or call its own witness. Each party is entitled to cross-examine a witness called by the court. A party may object to the court's examining or calling a witness either at the time or at the next available opportunity when the jury is not present. So the hearsay rule is here on page 34. So, hearsay is a statement other than one made by the declarant while testifying at the current trial or hearing, offered in evidence to prove the truth of the matter asserted. If a statement is hearsay and no exception rule applies, the evidence must be excluded upon appropriate objection. The reason for excluding hearsay is that the adverse party was denied the opportunity to cross-examine the declarant. And I think that's what, Sixth Amendment? Whatever, I'm not writing it down. Exam tip, an out-of-court statement that incorporates both hearsay within it, hearsay within hearsay, or double hearsay is admissible if both the outer hearsay statement and the inner hearsay statement fall within the exception to the hearsay rule. Which is interesting because, even when you see that in an MBE question, you have to basically assume that the person who wrote the question knew that was going to be the case, and it has to be sufficiently clear. Otherwise, you might see something that literally the writer of the essay didn't see, and you may say it's admissible because you know that there's 2 exceptions to hearsay, but the exam writer doesn't know that you saw that because they didn't think of it, and so you get the question wrong. So just be careful, I guess. Statement is defined here. Offered to prove the truth of the matter is here. What's underlined here is verbal acts or legally operative facts. Statements are not hearsay if they're out-of-court statements, right? Or verbal acts or legally operative facts. Statements offered to show their effect on the listener or reader are to prove notice in negligence case is an out-of-court statement that is not hearsay, as well as statements offered as circumstantial evidence of a declarant's state of mind. For example, evidence of insanity or knowledge. Do not confuse statements offered as circumstantial evidence of a declarant's state of mind, which are almost always offered as evidence of insanity or knowledge, with statements that reflect directly on character state of mind, which are usually offered to establish intent. The former is not hearsay, and the latter is hearsay subject to a specific exception. Deciding whether, actually, this is the most difficult part of evidence for me, so I'm going to reread this. Do not confuse statements offered as circumstantial evidence of declarant's state of mind, which are almost always offered as evidence of insanity or knowledge, with statements that reflect directly on declarant's state of mind, which are usually offered to establish intent. The former, circumstantial evidence, is not hearsay, while the latter, reflecting directly on the declarant's state of mind for intent, is hearsay subject to a specific exception. So what is not hearsay? I know this is kind of funny. Maybe I should actually read this. Statement, for purposes of the hearsay rule, statement is a person's oral or written assertion or nonverbal conduct intended as an assertion, such as a nod of the head. It is offered to prove the truth of the matter asserted. If the out-of-court statement is introduced for any purpose other than to prove the truth of the matter asserted, there is no need to cross-examine the declarant. So the statement is not hearsay. The following out-of-court statements are not hearsay. Verbal acts are legally operative facts, such as words of contract, defamatory word, statements offered to show their effect on the listener or the reader, to prove notice in negligent case, and statements offered as circumstantial evidence of declarant state of mind, for example, insanity or knowledge. In deciding whether evidence is hearsay, ask yourself whether we are relying on the declarant's credibility. Does it matter whether the declarant is telling the truth? If not, the evidence is not hearsay. So this is hearsay flow chart that I was going to look at and kind of quit because I figured but no, there's way more important stuff going on. This whole section is actually incredibly important. So I'm not going to go through the flow chart. I'm not going to read through the flow chart because that always sounds pretty rough. Actually, I will. First question, is the evidence a statement for purposes of hearsay, i.e. is an oral or written statement for or conduct intended to be a substitute for words? If not, it's admissible. Non-assertive conduct is not hearsay. Yes, if it is a statement, is a statement offered to prove the truth of the matter asserted? If no, it's admissible because it's not offered for the truth. And those three things I just read twice are being said again. Now, if it is being offered for the truth of the matter asserted, is it a prior inconsistent statement given by the declarant under penalty of perjury? If yes, it is admissible non-hearsay. I get that now. The way that is being put here, he's under oath. So it's not hearsay. I feel like everyone else confuses me. Is this statement, but if it's not that, right, the next question is the statement a prior consistent statement offered to rebut a charge that the witness is lying or exaggerating because of some motive, or offered to rehabilitate a witness who has been impeached on some other ground other than a general attack on the witness's character for truthfulness. If the answer is yes, it's not hearsay. But it never said anywhere in here that all of this was occurring under oath, like penalty of perjury, which I feel like is critical. But nonetheless, that has to do with prior consistent statements, which there's another kind that's not written here, which makes me confused. Nonetheless, if the answer to that is no, is the statement one of identification of a person as someone the witness perceived earlier? If so, it's not hearsay. If not, ask yourself whether the statement was made or adopted by a party to the action or by a spokesperson authorized to speak on her behalf, her agent concerning a matter within the scope of the agency, her partner within the scope of a partnership or business, her co-conspirator in furtherance of conspiracy, or her privity in title, giving parentheses, state courts. If it is an agent admission, I suppose that's what, in other words, an agent admission, it's admissible, and it's not hearsay. So that doesn't have to be under oath either. And so they may not be saying it on purpose. Hearsay. So if not, then hearsay inadmissible unless one of the hearsay exceptions applies. I'm going to those exceptions right now. Excited utterance, present sense impression, present state of mind, present bodily condition, statement for medical diagnosis or treatment, recorded recollection, business records or absence thereof, public records and reports or absence thereof, records of vital statistics, judgments, agent documents, documents affecting property interests, learned treaties, reputation, family records, market reports. And here's a nice table of what's non-hearsay and what's hearsay on page 47. This is like the end of the section. I will do until we get to procedural considerations, which is burdens of proof and presumptions. given some specific ones. Relationships of parties, judge, and jury. Sure, I knew any of that stuff. But the hearsay exceptions in the same order I just said them, probably obvious to know what they are from the definition. So I'm reading only the definition of hearsay exceptions. The statement made while under stress or excitement of startling event, statement made concurrently with perception of event described. That's your present sense impression, which is important to distinguish from present state of mind, which is statement of then existing state of mind, emotion, or sensation, usually introduced to establish intent. Admissible when state of mind is a material issue or to show subsequent acts of declarant. Spontaneous, and so the next one is spontaneous declaration of physical symptoms, followed by statement of past or present physical condition or the cause of the condition made for the purpose of diagnosis or treatment. Record, this is recorded recollection, record by witness who cannot now remember the facts while made the facts were fresh in their mind. Business records or absence thereof is a record made in the regular course of business, consisting of matters within the personal knowledge of one with the business duty to transmit. Such a record may be used to show non-concurrence of event. Public records, records and reports of public agencies regarding their activities, and records of births, deaths, marriages, etc. Absence of public record is admissible to show non-existence of the matter. Judgments. A copy of a judgment and a prior felony conviction is admissible to prove the facts essential to the judgment. In the criminal case, it may be used for this purpose only against the accused. Ancient documents, statements in authenticated documents prepared before January 1, 1998. Documents affecting property interests, statements in document affecting an interest to a property, example, deed or will. Learned treaties, statements from authoritative works, admitted if called to attention of expert witness and established as reliable authority. Reputation evidence concerning a person's character, a person's personal or family history, land boundaries, or a community's general history. That's crazy to me that's admissible over character evidence restrictions. Family records, statements of fact found in Bibles, jewelry, engravings, tombstones, etc. And market reports, and public compilations generally relied on by the public or persons of a particular occupation. And so when I record again, it'll kind of be straight through page 36 to 50, 51. And the only thing it will do is avoid the table of hearsay exceptions I just read. There is a new admissible out-of-court statements table that I didn't go into, and I'm going into it right now just to clarify that non-hearsay is non-assertive conduct statement not offered for its truth, prior inconsistent statement made under oath, prior consistent statement offered to refute charge that witness is lying or exaggerating, prior consistent statement offered to rehabilitate witness impeached on other non-character ground, prior statement of identification, opposing party statement, including vicarious admission. That's that last kind of agency sort of definition here, which was the statement made or adopted by a party to the action or by a spokesperson authorized to speak on their behalf. I'm reading agency admission here. That's got to be what this is. So a spokesperson, the statement made or adopted by a party with the action to the action, or by a spokesperson authorized to speak on their behalf, like their lawyer, her agent concerning a matter within the scope of the agency, her partner within the scope of a partnership business, her co-conspirator in furtherance of the conspiracy, or her privity and title. And I think as I'm learning in NBE, employees that were involved in a tort, maybe. So I'm going to end here. Remember, starting on page 36 to 50 in the next recording.